going to talk about President Obama's new Provisional Waiver policy. Let me start by telling you who needs a waiver. Under traditional immigration law, if somebody committed a crime, somebody committed fraud, somebody was unlawfully present in the United States for over 180 days and then left the country, they can't just get a green card and come back. They need to get a waiver to come back, and we call those I-601 waivers. The problem is that, let's say we had a married couple and they had children, and the husband went abroad and had to apply for the waiver. It was often many months, sometimes even over a year, that the couple would be separated while the agency processed the waiver application. So what the new policy does is shortens that period by allowing the person, before they go abroad, to apply for the waiver in the United States. But it can be confusing to non-immigration lawyers because it's not all kind of waivers. It's only waivers for unlawful presence in the U.S. So if you've been unlawfully present in the U.S. for, let's say, a year, and you also had committed a misrepresentation or you had a crime, you cannot take advantage of this new policy. You can only take advantage if all you need a waiver for is unlawful presence. The new policy is going to go into effect. I'm making this video in January of 2013, and it will go into effect starting March 4th of this year. Now, the policy is rather limited. I told you it's to prevent that long family separation, and it allows people to apply for waivers in the U.S., but only certain people. Let's say you're coming under the preference system. You're sponsored by your employer. You're sponsored by your brother, and you're in one of these limited family or employment preference categories. You're not eligible for the waiver. So just forget that. You'll have to go abroad and apply for the old 601 waiver and stay there however many months you have to. So who is eligible for this? Well, first of all, only immediate relatives. So who is an immediate relative? 3 people: a child of a U.S. citizen, a parent of a U.S. citizen, or a spouse of a U.S. citizen. Also, this will only apply to people who are ineligible to adjust their status in the U.S. If you come on a tourist visa and end up marrying a U.S. citizen, you can get your green card without leaving the U.S. But if you entered without inspection, which means you didn't see an immigration officer, you saw a coyote or somebody smuggled you across the border, something like that. Or in certain cases, there are certain visa types that don't allow you to adjust your status in the U.S. The most notable being people who come on a C1 crewman visa, or people who come as K1 fiancés, and instead of marrying the person who sponsored them for the K1 fiancé visa, they end up marrying somebody else. It has to be that you are ineligible to adjust your status in the U.S., and under the new policy you must be at least 17 years of age to apply. Now, let me talk specifically about the unlawful presence bars, because there's 3 different bars, and this policy only applies to the first 2. If you come to the U.S. either unlawfully, you overstay your visa, or you violate your status, like working without permission, and then you get caught by immigration, and you rack up over 180 days of unlawful presence, and then you leave the U.S., not under voluntary departure from a judge, but just leave the U.S., you can't come back for 3 years. Now, if you're an immediate relative and all the other qualifications I went through, you can do the waiver of the 3-year bar in the United States. And the 10-year bar is very similar. The only difference in the 10-year bar is that you have to be in the U.S. unlawfully for over a year, not just over 180 days, and be given voluntary departure for the judge doesn't help you at all the way it waives the 3-year bar. So if you're under the 3-year bar, the 10-year bar, you can take advantage of this policy. On the other hand, if you're under what we call the permanent bar, you cannot take advantage of the policy. And who's under the permanent bar? People who are under the permanent bar are people that have accumulated enough unlawful presence in the U.S. to be under the 10-year bar and then come back illegally to the U.S. Or they're deported from the U.S. and they come back illegally to the United States. Those people have to stay out of the U.S. for 10 years before they can even apply for a waiver. So if you're under the permanent bar, don't even think about applying for a provisional waiver. Now, once you know that you are eligible, how do you go about this process? Well, you have to be able to show extreme hardship to an immediate relative. But the questions are, what is extreme hardship and who is a qualifying relative? And by the way, I said immediate, but not all qualifying relatives and immediate relatives, it's not exactly the same category, so I want to explain. Let's say your situation is you came to the United States, you were unlawful for a period of over 6 months or over a year. You came illegally, and then you married a U.S. citizen. So you're not eligible to adjust your status in the United States. I didn't mention before, but some people are under Section 245I, even though they came in without inspection. And if you're under that, please see our video about 245I, because that might be able to help you. But if you want to prove extreme hardship and you just got married, well, good luck. I mean, I don't think you should apply for a provisional waiver because extreme hardship is defined as something that goes beyond the regular hardship. So I just crossed the border from another country illegally. I got married to a U.S. citizen. I can't adjust status. But really, you know, my wife wasn't married to me 2 days ago or 2 weeks ago or 2 months ago, whatever it is. So why would her hardship be extreme? Well, you know, if she's dying of certain disease or I'm treating her or something, possible. But most new marriages, you're not going to qualify. So my best advice is wait till you have kids, and then, especially if that person's the breadwinner in the family, and how they're going to work and take care of the kids. Now you're starting to get closer to extreme hardship. And extreme hardship might be medical, it might be emotional, it might be financial. There's a case called Cervantes that all immigration attorneys know, and you may want to be acquainted with yourself, that explains the standards for extreme hardship. But who does that hardship have to be to? Well, it has to be to a qualifying relative. And I said, not all immediate relatives are qualifying relatives. To be a qualifying relative, it must be your spouse, or it must be your parents that are going to suffer extreme hardship. And under this policy, your spouse or parents are going to have to be citizens, or at least somebody's going to have to be a citizen for you to apply for one of these waivers. So you have to be really careful about that. But let's say your wife is a U.S. citizen and your parents happen to be permanent residents. Who's qualifying relative for the purpose of hardship? All three. Okay. Now, what if you do all this? And I know that despite my advice, people that are going to get married on Monday are going to try to file for the waiver on Tuesday. Bad idea, but not everybody sees this video. So some of these waivers, and we call them I-601A waivers, as opposed to the I-601 waivers that you file abroad. And the I-601 waiver, what if it's denied? I mean, can you appeal? No. Can you do a motion to reopen or put in new evidence? No. So that's kind of tough, isn't it? I mean, usually under the immigration laws, there's appeals, there's motions to reopen. But the good thing about this is if you go to somebody who's unqualified or you do this yourself and it gets denied, hopefully the second time you'll wise up and go to the right person and you can refile for the waiver. So whether you're doing it the first time or the second time, I mean, what are your real chances of having one of these waivers approved? Traditionally, we've looked at the statistics in the last year for the I-601 waivers abroad. 34%, or over 1 out of every 3, were actually denied. And then if you want to go through an appeal process, it could take years. So you really want to make sure you do this right. So here are Shusterman's rules. Don't do this yourself. I mean, if you can't afford it, then just don't do it. Save up until you can afford it. Also, don't use a notario. These people are not attorneys. Don't use somebody who calls themselves an immigration consultant. That means it's just another way of saying they're not an attorney. Use somebody who is an immigration attorney, who's experienced, who's done a lot of I-601 waivers, and they know what the standards are for what is extreme hardship. That's by far your best bet. Now, I know in 7-8 minutes it's really hard to absorb all this, so what if you want to read something online? I created a frequently asked questions for provisional waivers on our website, and we'll be showing a slide, or you're seeing a slide maybe, that shows the address of the page. And in addition, the USCIS, the Immigration Service, they have a slide, FAQ that shows this, and so does the State Department. So click on any of the pages that we show you, and maybe you want to read all 3 FAQs, because there's, if you're under deportation proceedings or you're trying to get a fee waiver and so on, we really don't have enough time to cover it here. So be sure to get that information, and good luck with your waiver.